Four components we are going to cover today. Hope we'll able to finish. If not, then we'll carry something for the next class. So first component is jurisdiction, second component is sanction, third is cognizance, and fourth is complaint. Four things we are going to discuss today. Now, jurisdictions of the criminal court in inquiries and trials. So when you look at in the BNSS or even when it was CRPC, the same wording was that the judiciary, what it appear that the CRPC or for that purpose BNSS, they did not talk about the police jurisdictions. Many times someone go to the police station for registering FIR, and we invariably heard that police refuse on the ground of jurisdictions. But the CRPC nowhere talk about police jurisdictions. CRPC talk about court jurisdictions. Yes, from there it's flow to the police power or police jurisdictions. Now in the BNSS, when FIR provision 173, they have removed that jurisdiction's obligation. It says irrespective of jurisdictions, police is bound to register FIR. So, but those kinds of allegations come that many times jurisdictions issues raised by the police officers and they don't register FIR or they don't start the cases. But we look at the way the CRPC or BNSS is drafted, is only one place have jurisdictions. You will find the wordings of this chapter is so broad that for a single offense, there might be multiple jurisdictions. There are many places cases can start. There are many places where trial can be conducted, and that's possible. And there are justifiable reasons for it, why this law has drafted in such a manner where they have given very broad aspects of the jurisdictions. So when we look at this, you'll find section 197 to 209, this entire broad ambit of the jurisdictions. Now, a large number of sections are there, but we'll not devote much time to in these sections. I'll just try to explain. So again, after class, if you have any difficulty, just look at this video along with your provisions in the BNSS. I think will give clarity to you. So when we talk about the jurisdictions, let's start with 197, first section. First sections talk about ordinary jurisdiction. Now we understand ordinary jurisdictions implies the place where something offense being committed, etc. So the first section, very simple way, it says every offense shall ordinarily be inquired into and tried by a court within whose local jurisdiction was committed. So the place of occurrence. So ordinary jurisdiction is place of occurrence. Wherever the offense is committed, that local court have jurisdictions. When that local court have jurisdictions, that local police has jurisdictions. 177 it was earlier, now become 197. But when you look at the jurisdiction chapter, it's not only one sections. And see how the basic principle of jurisdiction has expanded in the CRPC as well as in BNSS. So, Kaushik Chatterjee University of Haryana, principle and factors that need to be kept in mind while determining jurisdictions territorial of criminal courts in inquiries and trial. Explain, court says how you can say, but first section is itself ordinary jurisdictions where the trial can be conducted. Unlike in CPC, when we look at CPC, when you have seen the CPC where we try to differentiate between jurisdictions, pecuniary jurisdictions, territorial jurisdictions, subject matter jurisdictions. Now, CRPC in that way does not talk about, but yes, what is there in this chapter? This entire chapter is talking about territorial jurisdictions. Then we can say that, okay, the schedule of the BNSS talk about which case can go to the magistrate court, which can go to session court, etc. Subject matter. Or you can say pecuniary, because of the offense, gravity of the offenses, can go to one court or other court. And then you have many special court where specific cases can go to specific court. So there are courts for Essential Commodities Act, there are courts under NDPS Act. So in that way, many legislations under which you have a special court, POXO special courts are there. But when we talk about this chapter is talking about territorial jurisdictions. Same way Scott Limited versus Rama Mukherjee. Court within whose jurisdictions check was presented and dishonored also have jurisdictions to try offence under 138 Negotiable Instrument Act. Swati Nirkhi versus State. Ordinary place of inquiry or trial has to be by the court within whose local jurisdiction the crime allegedly committed, or where the cause of action accrued. Meaning of the cause of actions, court has explained what does mean. So basically, wherever there is a offense being committed, that court has a ordinary jurisdictions, a territorial jurisdictions. Now that first section 197 talk about the ordinary jurisdictions, but when we gradually see other sections, the concept of jurisdictions expanded, made it very broad. So accordingly, when we see this entire chapter on jurisdictions, you will find that many offenses might have multiple jurisdictions. So 198, what it says, you have A, B, C, D, four things. A, when it is uncertain in which several of the local areas offense was committed. So person was going through and committing crime, not sure which several areas the offense was committed. Where an offense was committed partly at one local area and partly in another. So you'll find some localities are there. The one side of the road has one police station, other side of the road has other police station. Someone started beating at one side, did ultimately in the other side something. So partly one side, partly other side. Third, where continuing nature. Suppose a girl is being abducted by perpetrators in Calcutta. In the vehicle, it goes through, say, your North 20 Pargana, Barasha, through there, Malda, etc. They went to Siliguri. And ultimately from Siliguri, after reaching, they started calling ransom, etc., etc. Which court have jurisdictions? Now this is a continuing offense. It started from one place in Kolkata. Wherever the girl was in the vehicle as a being kidnapped victims, the offense continues. And continues till the time even in Siliguri, from where they have asked for ransom, etc. Which could have jurisdictions? D, where it consists of several acts done in different local areas. Someone sitting in Bombay has given a threat that you paid money, otherwise your child will be kidnapped or abducted. The child being abducted in different place. The person waited and paid money in different cities, 3 different cities. Which court will have jurisdictions? You see, law says it may be inquired into or tried by a court having over any of such local areas. So very broad concept. It's not only one place the trial can be conducted, or when a trial can be conducted, investigation can be conducted also. So it's not only one place they have jurisdiction, the jurisdictions are at multiple places. And that's the concept which we find in 198. It was earlier 178. Same thing what was in CRPC, the same thing has incorporated here. 199. Again, very important concept. Offense done at one place, consequence ensues. Suppose a lady from Calcutta got married to a man in Delhi. So her in-laws place in Delhi. Every day in-laws torture her. And she in the night called to her mother, look, this thing happening, I will not survive, I will die, I will commit suicide, etc., etc. Where the offense impact is? In Kolkata also. Someone did something sitting somewhere in cyber crime. We know so many things happened. So people sitting in some place in Jharkhand, making phone call, etc., asking the persons to transfer money. The person sitting in Calcutta transfer money. Where it can be? Any places. Where act done, where effect ensues, consequence ensues. So 199 says, when an act is an offense by reason of anything which has been done and of a consequence which has ensued, the offense may be inquired into or tried by a court within whose local jurisdiction such thing has been done or such consequence has ensued. So where impact was, so where either act was done or where the impact of the offense was, in both places you will have jurisdictions. Suppose someone's went for invitations. So Calcutta's boy went to Barasat for invitation with a friend, but friend was an enemy. He does not aware about it. That friend invited for dinner, or say in the dinner in food we mix poison. He took food, does not impacted immediately. He came here, his condition started deteriorating, and in Kolkata that boy died. Where offence was committed? Barasat or other districts. Where ensues? Kolkata. Which place have jurisdictions? Both of them. So the way this entire chapter on jurisdiction has been drafted, it given jurisdictions for one offense, the jurisdictions can be at multiple places. So under 199, where act was done or where effect ensues, so where the consequences are, even those places, they will have a jurisdictions. 200. When an act is an offense by reasons of its relations to any other act, which is also an offense, or which would be an offense if the doer were capable of committing an offense, the first mentioned offense may be inquired into or tried by a court within whose local jurisdiction either act was done. So one act done in one place, other thing is some other places where if that may be in offenses, handing over the money, cheating. So there could be many circumstances that can be jurisdictions. 201, place of trial in cases of certain offenses. Now again, so you find from 197 onwards, 97, 98, 99, 200, they talk about itself different jurisdictions. Only first section says where offense is being committed. So they broadly expanded the jurisdictions. Now in 201, you will find further new concept has been brought in respect of the jurisdictions. So in 201 clause 1, suppose there was a dacoity being committed at one place, someone's home in Calcutta, or dacoity with murder. Now that dacoit ran away and they were hiding in Malda. All the money which they have taken that were found in, say, in Siliguri or Asansol, where the trial can be, in all these places. So, or of escaping from custody, maybe inquiry into tried by the court in local jurisdiction, the offense was committed or accused person was found. So, wherever accused was found, trial can be conducted. Kidnapping, abductions. So, the person is kidnapped or abducted, and then the person is taken to different cities or different places. Where the jurisdiction will be? All places, wherever the person was concealed, conveyed, detained, all places they have jurisdictions. So any offense of kidnapping, abduction, etc. be inquired or tried into court within whose local jurisdiction the person was kidnapped or abducted or was conveyed or concealed. So all places wherever the person was taken, they have a jurisdictions. So look at the jurisdiction chapter. It is such a broad worded that for one offense there could be multiple jurisdictions. Now, why they did it? The only reason is so that the accused can be tried in any of those places. No one can claim that, okay, the court does not have jurisdictions. 3, theft, extortion, robbery. Wherever this thing is done, now that can also cover under 197. Or where those property is being found, there also can have a jurisdiction under clause 3. So someone committed theft in Calcutta and he sold the property in, say, Dhanbad. Both places jurisdictions. He committed theft in Calcutta, sold the property in Asansol. Both court has jurisdictions. 4, any offense of criminal misappropriation or criminal breach of trust, where they will have jurisdictions, where this offense is being committed or where those properties, etc., is being kept, reported, kept, etc. So accounted for. So any offense of criminal misappropriation or criminal breach of trust may be inquired into or tried by a court within whose local jurisdictions the offense was committed, or any part of the property which is the subject of the offense was received or retained or was required to be returned or accounted for by the accused person. So suppose someone is an agent of Tata and the Tata Tiscon company, their head office is in Bombay. So he was sent to collect money from Calcutta. He took money from Calcutta. He's supposed to return back to Bombay to hand over. But he took all this money. He went to Delhi with his family and enjoyed the money. Where the jurisdictions are? Definitely, this all wrong has been done in Calcutta. Calcutta have jurisdictions. He was supposed to return the money in Mumbai. Mumbai have jurisdictions. He took the money to Delhi and enjoyed that money there. Delhi has jurisdiction. So when you look at the jurisdiction chapter, you will find for one offense, you'll have multiple places will have automatically they have a jurisdictions. 5, any offense which include the possession of stolen property may be inquired or tried by the court in his local jurisdictions. The offense was committed, stolen property was possessed, or any persons who received knowingly having stolen property. So in all places they will have jurisdictions. Now 202. So now you see gradually the concept have become much larger. 202. Offense committed by means of electronic communications, letter, etc. Someone sent a letter from Delhi, defamatory letter. Letter reaches in Delhi. The person who received it, he felt defamed and he wanted to file a case. Where the case will be? Both places. It can be in Delhi, it can be Kolkata. Someone sent email from Bangalore to someone sitting in Calcutta, and that email communication is defamatory in nature. It can tie into both places, Bangalore and Calcutta. Someone say letter bomb, and as soon as the bomb opened by some letter was opened by someone, there is a blast. Where it was sent, where it is received, all have a jurisdictions. So under 202, you find these sections under which the jurisdictions again expanded. So the jurisdiction chapter has very broadly worded so that the multiple court can have a jurisdictions for conducting the trial. Now it's the same language what was earlier, the same thing has been kept there in the new law. 203, offenses committed on journey or voyage. Remember, when some offense is committed in journey or voyage, etc. Suppose if someone boarded a train in Kolkata, Howrah station, he is going to Delhi. Early morning, as soon as he wake up, he found that his baggage is not there. No, in between he cannot get down also. So he has to go to Delhi. He reaches Delhi and went to RPF there, GRP office for registering FIR. Does GRP have jurisdiction? Answer is yes. Which PS has jurisdictions? Starting from Howrah stations to Delhi stations, all the places wherever this train goes, they will have jurisdictions. You see the language, the beauty of language. Many times we see that, okay, someone claim that, okay, no jurisdictions, etc. Very broadly worded. Had this broadly worded language was not there, when you have seen the case in arrest issues, Arnab Goswami case, throughout the country, many places people file FIR against them. Why so? Reason being, there are jurisdictions in all places. Because the language is such, the way the jurisdiction chapter is drafted, it given options for different places to have jurisdictions. 204, place of trial for offences triable together. Now, we will discuss this when we discuss more detail, when we discuss about the charge provisions. There are concept of joinder of charges. So when the different offences can be charged together, accordingly, trial can be conducted in any of those places. So the offence of committing by any persons are such that it may be charged with and tried at one trial for each of such offences by virtue of 242, 243, 244. Or the offence or offences committed by several persons are such that they may be charged and tried together with by virtue of the provision of 246. Trial can be at any places where they can inquire and trial. 205, power to order cases to be tried in different session division. Now a very interesting part has come. So we have seen that one offences might have a multiple jurisdictions. So how to deal with them when someone has filed multiple cases for one offence? So here, the answer you will find in these 205 and subsequent 6, etc. So 205 says, first section says, notwithstanding anything contained in the preceding provisions of this chapter, the state government may direct that any case or class of cases committed for trial in any district may be tried in any session division, provided that such direction is not repugnant to the directions previously issued by the High Court or the Supreme. Why, anyone idea why this power has been vested to government? There was a case in Calcutta. It's called Purulia armed rob case. So one person's probably named Peter or something, British national. He came with helicopter, etc., and dropped a large number of arms and ammunition in Purulia in West Bengal. In fact, that ammunition arms reached to different groups there. Now, conducting trial in Purulia is not safe. Now, under this section, the government can pass order to transfer that trial to other districts. So, trial was conducted in Calcutta. So, in that way, there might be some circumstances where such sensitive cases where it's difficult to conduct trial at the place where this is become difficult in some cases. Then in those circumstances, the trial can be conducted at other district or other session division. That's the basically this section has provided, and in fact this section has been used in many cases for that purposes. Now this is one, but there may be other circumstances. Suppose one offense or one fact, there are multiple cases filed in the different district of West Bengal. Accused should not get trial for all cases. In all jurisdictions, one offense, multiple FIR. Accused double jeopardy rights are there. So accused normally file an application. So the idea is the accused will file application under 206 to the High Court. What the High Court can do? So where two or more court have taken cognizance of the same offense, and a question arises as to which of them ought to inquire into or try the offense, the question shall be decided as follows. A, if the courts are subordinate to same High Court by that High Court. If the courts are subordinate to the same High Court by the High Court which are not subordinate to same High Court, so different High Court, then in those cases, the High Court within whose jurisdiction the first case was filed. So that's the formula which BNSS or CRPC has given. It was earlier under 186 CRPC, not 206 BNSS. And this happened, it's also used in many circumstances where say something happened in one place and the people file cases in multiple places, then High Court say, okay, which session division the trial will conducted. 207, power to issue summon or warrant for offence committed beyond local jurisdictions is a basic procedural power which the court has. So when they can issue summon, etc., not much to discuss. Offence committed outside India, when someone has committed offence in India, we know in IPC, now in Nyaya Sanhita also the same provisions are there. So a Indian citizen, if they commit offence outside India, if some offence committed on Indian ship, Indian voyage, etc., then because those things carry the territory of India, ship, aircraft, etc., if the offence committed there, then those airlines or the ship, they carries Indian territory, and accordingly India has power to conduct the trial. So in those cases, it can be offence conducted trial at any places. So he may be dealt with respect to such offence if it has been committed at any place within the India. So in that way, that it has been dealt with. So persons can be tried. 209, receipt of evidence relating to offence committed outside India. It's a process by which we can take evidences from the other jurisdictions. Law permit to take evidences from them. So that's the basically jurisdiction chapter. So first part, what we discuss. So the jurisdictions is a very broadly worded, and there are invariably there are circumstances when one offences can be tried in multiple places, that possible, and then the remedy also provided that if there's a multiple places trial is going on, what accused can do? Accused can ask in the superior court for bringing the trial at one place where the trial can be conducted. So the next topic we are going to discuss is basically chapter 15, which heading says conditions requisite for initiation of proceeding. Remember, the criminal process start, first phase is to take cognizance. So in a complaint case, magistrate take cognizance and then matter proceed. In even police cases, when police submit charge sheet, the magistrate take cognizance first and then matter proceed. So cognizance is one of the important step from where formally cases begin. But at the same time, in the law, we have put some limitations, some restrictions on this cognizance power. One of them is sanctions. There are others also. So we can say there's a condition requisite, some limitation. Many times when we put restriction in such a manner that rarely cases comes. So in IPC, we have the provision for bigamy. How many cases you find of bigamy? Is it we don't have bigamy in India? Even the population which with their target, so like bigamy is prohibited in other than Muslims in others, so it should be punishable offenses. Many studies suggested that bigamy, number of percentage of bigamy is more in, there are other groups, other communities. Why there are no cases of bigamy? Why you don't see cases of bigamy? Anyone has any idea, any views? So bigamy is a penal offense under the IPC, but when you have a penal offense, there should be FIR, there should be cases. Why don't have cases? Anyone has any idea? Or maybe adultery was offense. Now they have removed. It's offense for quite long time. But why we don't see much cases on adultery? People said argue that even court says it's violate equality principles, etc. But why we don't have cases? So we have a provision, we have penal provisions, but no cases or real cases. Rarely we find any cases. The reason being not your penal provision, your IPC or non-Nyaya Sanhita, but your CRPC or BNSS. Who can file the case for bigamy? Only aggrieved party. In bigamy cases, who are the aggrieved party? First wife. In our socio-economic system, where the women has no economical empowerment or movement, rarely women go and file a case against her husband who did second marriage. So despite that bigamy is an offense, it rarely implemented. Few years back, we are seeing it becomes a national news, Haryana or probably Punjab or someone, the deputy chief ministers, he converted to Islam, wife name was converted to Chand Banu or something, and there is national media. But why no FIR? Why no cases? We say bigamy is an offense. The reason being that the case can be filed only by the first wife, and in our economic system, where we exist a large number of women whose husband did second marriage, they are dependent economically on their husband, and accordingly they don't go to take this legal actions against the husband. So this in turn give impunity for these kind of offenses. So people when do these kind of offenses, they get impunity. They know my wife will not file a case. Now NGO cannot file the case, you cannot file the case, other persons cannot file the case. While there are maybe some other, even there is a theft of 100 rupees. Who can file the case? Anyone. Theft of 1,000 rupees. Anyone can file the case. Beating. There are some fight in the college premises. Anyone can file the cases. But there's such a serious thing happened. Bigamy. A life being destroyed of the women. You cannot file the case. You cannot start the cases. Where we'll find that? There is a conditions requisite for initiation of proceedings. This chapter. This chapter puts those obligations that in certain cases, before starting cases, you have to fulfill some requirement, eligibility criteria, who can file the cases. So either you sanctions require or locus standi has been given to only a specific class of people who can bring those cases. And that's why we don't find much cases of bigamy, adultery, etc., etc. So let me see what are those conditions present, precedent, etc. So first sections talk about cognizance, 210, and then we'll gradually we see 222. Till there we have these sections. So cognizance and sanctions, limitations, all we'll find in this chapter. So let me quickly see first cognizance, and then we'll come to that limitation part. What does cognizance means? Cognizance simply imply taking note of, taking action. Earlier it was 190 CRPC, now it is 210 BNSS. So, when court process against the accused, we consider court has taken cognizance under 210 and proceed further. So, a court therefore is precluded from entertaining a complaint or taking notice of exercise of jurisdictions if it is of the public servant who is accused. There is a requirement for sanctions, etc., who had done something in discharge of their official duty. So, there are limitations. One limitations are of sanctions. So, in K. Kalimuthu versus State, court says several provisions in chapter 14 of the CRPC use the word cognizance. The very first section, that is 190, now that become 210, lays down how the cognizance of the offence will be taken by a magistrate. However, the word cognizance has not been defined. The dictionary meaning of word cognizance is judicial hearing of the matter. The meaning of the word has been explained by judicial pronouncement and has been acquired at different connotations. So you'll find R.R. Chari versus State. This says taking cognizance does not involve any formal or indeed any kinds of some kinds of formality. It occurs as soon as the magistrate as such applies his mind to the suspected commission of offence. So as soon as he applied the mind to the suspect criminal offences, took actions, that means he proceed and send the summon to other side. In Darshan Singh case, court says while considering 190, it says cognizance therefore take place at a time when a magistrate first take judicial notice of an offence. This is the positions whether the magistrate take cognizance of an offence on a complaint or on a police report or upon an information of a person other than the police report. All these are possible. Magistrate can take cognizance on own, magistrate can take cognizance on complaint, magistrate can take cognizance on the police report or other informations. State of West Bengal versus Mohammad Khalil, court says in its broad and literal sense, it means taking notice of an offence. So, cognizance implies taking notice of an offence. The word cognizance indicate the point when a magistrate or a judge first takes judicial notice of actions of an offence. It is entirely a different thing from initiation of proceedings. Rather, it is a condition precedence to the initiation of the proceedings by the magistrate. So, any criminal trial really start after cognizance, the first step when the magistrate take cognizance and then the persons proceed. So, cognizance taken of cases and not of the person. So, whatever the offences are there, of which cognizance being taken. In the state of Karnataka versus Pastar P. Raju, court says taking cognizance of an offence is not the same thing as issuance of process. In fact, now the things have changed in BNSS. We'll discuss in 223 when we talk about complaint cases. But earlier system was when the court issue notice under 204 CRPC, they take cognizance and then only they issue notice. That's the basic procedures. So the issuance of process is at a subsequent stage when after considering the material placed before it, the court decide to proceed against the offenders against whom a prima facie case is made out. So when we look at the word cognizance, after taking cognizance only of all the materials, etc., then court proceed for sending notice, etc. Subsection 2 of 167 will show that even a magistrate who has no jurisdiction to try the case can authorize the detention. So there is a power under which a magistrate can give detention. Now under 167, that again the number has changed now. Even there is a provisions of the executive magistrate to give detentions order. Now we come to what does cognizance section says, 210. Earlier it was 190. So on what basis court can take cognizance? Three things it's written here. A, upon receiving a complaint of fact, including any complaint filed by the person authorized under any special law, which constitutes such offences. Now, why this word has been used? Including any complaint filed by a person authorized under any special law which constitutes such offence. Interestingly, if you see the functioning of NDPS Act or even forest relating laws, you will find this the Central Narcotic Bureau personnel under that act, they go and file a cases in the court directly. That's what it referred to. Similarly, many forest department officers, they don't register a fire in the police station because they don't want to lose the cases. They do deal with the case themselves. And they go this complaint system, that process they follow. B, upon a police report, the second thing on which the magistrate can take cognizance. C, upon information received from any other persons other than police officer or upon own knowledge. So either third party information or own information. So can a magistrate take cognizance on own information? Answer is yes. It's provided in clause C of section 210. Magistrate can take cognizance on the basis of own information. Clause 2 empower the CJM, who can in turn give authority to other magistrate to take cognizance. Second class. No, in West Bengal, we don't have any second class of judicial magistrate. So, this taking cognizance of the offense, in Raghuban Dubey case, court says taking cognizance of means cognizance of the offense and not of the offender. The magistrate under section 190, now that become 210, take cognizance of the case as a whole and he can take actions against the persons not mentioned in the complaint. That also possible. In Nihar Singh, court says, even after process has been issued against some accused, on one date, held process can still be issued by the magistrate against some other person. The reason? The cognizance is taken of the offense and not the person. If some other person's name brought in, magistrate can send notice to them later on. A criminal trial court cannot continue proceeding against a dead person and find him guilty. So, that need to be abated. Now, 210 talk about cognizance. 211 talk about very important thing is a fair trial principle. What is fair trial principle involved here? Now, in 210, we have seen C. 210 clause 1C. Magistrate can take cognizance on his own also, on own information. Now, when a magistrate takes cognizance on his own information, will it be fair for same magistrate to conduct trial? Is it not that you are becoming judge of your own cause? Accordingly, this 211 says that if the magistrate is taking cognizance under clause C of subsection 1, then he should inform the accused that he has a right to be tried by other judge. And if the accused submit application to tried by the other judge, the case has to be transferred to other judge for trial. I think it's a provisions to fulfill the requirement of fair trial. Because no one can be judge of his own cause. Complaint if he has summo taken cognizance of something that someone else should try. That's the basic principle. 212 says making over the cases to magistrate. So CGM can transfer the case to other magistrate. Now, many of you definitely gone to the different courts, etc. So the initially complaint is filed in CGM court. Now CGM cannot conduct all trial. What he can do? He can transfer to other courts. That's what happened. So transfer the cases, a magistrate who received the case on transfer and take cognizance would not become incompetent to do so merely because the sanction of the transfer of the case to his file is not in accordance with law. Cognizance of the session court. So when a session court take cognizance, remember in our system, cases does not file directly in session court. All the cases start from the magistrate court only because the charge sheet is submitted in the CGM court or ACGM court. And accordingly, what the 213 says, except as otherwise expressly provided by this Sanhita. We'll find in the last section what he's talking about of this chapter. Or by any other law for the time being in force. Any other law time being in force talking about like NDPS Act, Direct Session Court take cognizance, the special court. POXO Code, special court take cognizance. Essential Commodities Act, special court take cognizance. So there might be some special laws under which the law permit that the cases shall go directly to session court. But if you leave those apart, no court of session shall take cognizance of any offense as a court of original jurisdictions unless the case has been committed to it by magistrate under this Sanhita. Very important thing. No cases go to session court directly unless the case transfer from CGM court or ACGM court to the court of session. And that's what come from 213. So what's the procedure happened? Police submitted their police report in CGM court or maybe ACGM court. Then from ACGM court will ensure they will take cognizance. After taking cognizance, they will ensure that the copy, etc., has been delivered to the accused. And when all this formality is completed, then the case will be committed to the court of session. Once the case is committed to the court of session, then session court can take cognizance. Now again, in the district, there is only one session judge. Now alone he cannot conduct trial. So what he can do? So he can take cognizance 213 and then 214 says session judge can transfer the matter to additional session judge for conducting trial, etc. So then only once they transfer to additional session judge, then only additional session judge can take cognizance and not directly. So cognizance come only on that way. So an additional session judge shall try such cases as the session judge of the division may, by general or special order, make over to him for trial. Then only he will again proceed with the matter. Now we come to this section 215. Now, this section is about offense against public justice or for offenses related to document given in evidence. What is the process they have laid down? So, for contempt proceedings or abatement or criminal for conspiracy, etc., except on the complaint in writing of the public servant concerned. So, the persons against whose authority this contempt is being done or public justice violated, only those people can file complaint. Locus standi. You cannot go and file a case. I cannot go and file a case. Only those officers, public officers, can file complaint under 215. And they have given all those list of sections also under which they can file the complaint. So this Maji case, this 195 earlier, now 215, applies only in respect of the offence at 172, 188 of the IPC. Now the number has changed. You will find when these are public officers, etc., when the offence is committed against them. Bandekar Brothers Public Limited versus Prasad Vasudev Keni. Bar contained in section 195, 1 CRPC and procedure under 340 is mandatory in nature. Private complaint in relation to the offences covered in 195 held non-maintainable. So even if there are some kinds of offences against public officers, etc., the cases can only start when those public officers has filed cases, otherwise not. Nimaljit Singh Hoon versus State of West Bengal. The object and the purpose of 195(1) is it is the court before which an offence is alleged to have been committed in respect of the document produced. In a proceeding before it, should file a cause to be filed a complaint and not a private party. That's the requirement. Only they can file the cases. Same thing, Babita, Leela, etc. 216, procedure of the witness in case of threatening. So if the witness are being threatened, etc. Now in Nyaya Sanhita, which is a penal provision at 233. So either witness or any other persons can file those cases. Now we come the concept of sanction. So when we look at the concept of sanction, sanction means the permission, authorizations. So 217 talk about some specific kinds of offenses. So the prosecution for offenses against the state and for criminal conspiracy to commit such offenses. So any offenses which committed against the state or criminal conspiracy of it, we cannot start those cases without previous sanction of central government or state government. So before filing those cases under these sections like section 47, 299, 353, 196, etc., etc., in those cases, only with the sanction of the government, the matter can proceed. So court cannot take cognizance unless there is a sanction given by the authority. Other sections are also there, 197, 353, a criminal conspiracy of it, except with the previous sanction of the central government or the state government or the district magistrate. Clause 3, no court shall take cognizance of the offense of criminal conspiracy under 61, etc. Other than the criminal conspiracy committed an offense punishable with death, imprisonment for life, rigorous imprisonment for a term of 2 years and upward, unless the state government or district or some district magistrate has consented in writing to initiation the proceeding. So you'll find these are the, when it is the offenses are against the state, these are the safeguard that without authorization, without permission from the state government or permissions from the central government, without that permission, we should not start the proceeding. That basically the requirement or protection was the law has talked about. And then it's laid down the procedure of sanctions. So that's basically provisions for what we find for the sanctions requirement. Now we come to complaint. So there are other sections also for sanction. We'll come to complaint little later. 217, prosecution for offense against the state. This we have just discussed. 218, prosecution of judges and public servant. Again, very important sanction provisions. It's required sanctions. So under this provision, suppose there is a prosecution we want to start against police officer, against public servant, against the judges. Law is very clear. If they have done something in discharge of their official duty, you see the words, the third line. Offense alleged to have been committed by him while acting or purporting to act in discharge of the official duty. So if a public servant has done something in purporting to be discharge of an official duty, sanction is required. It laid on exception when the case is started by Lokpal or Lokayukta. But otherwise, in general conditions, we require sanctions from the state government or central government if those employees belong to state government or those employees belong to central government. Sanction is required. Without sanction, cases cannot be started. So very important sections, and these sections many times become instrumental in giving impunity to the public servant, and that's the challenging issues that how we can ensure that none of the public servant can be get impunity. At the same time, if something has been done in discharge of the official duties, etc., there is a need that the persons can be protected. Some protections required to be given. So, first provision says, provided that where the alleged offense was committed by a person referred to in clause B during the period which proclamation issued, then the sanction will be by central government. Another provision says, now the new thing has been added, and that's a very interesting thing. What's the new thing added? The new thing is added is, there's a new concept they brought in the sanction provision, is called deemed sanction. What is that deemed sanction provision? You see, proviso says that just read this section, that such government shall take an decision within a period of 120 days. Suppose in 120 days, if the government has not refused the sanction application, then this provision says it will be deemed to be sanctioned. I think it's very good provisions, because on many occasions, this will become an instrument to be creating some kinds of impunity for the public servant who did some kinds of a wrong. Now, if the government do not refuse for 120 days, then courts shall consider that's a deemed sanction, and they can proceed against those officer. Then this proviso, which was added later on in the CRPC, now brought here also, provided that no sanctions shall be required in case of public servant accused of offence alleged to have been committed under section 64, 65, 66, 68, 69, 70, 71, etc. So, in sexual offences, there are no requirement, no sanctions require. I think they have rightly done this. So, under 197 of the Act, these are sanctions requirement. Then clause 2 talk about armed forces, etc. So it says no court shall take cognizance of any offence alleged to have been committed by any member of armed forces of Union while acting or purporting to act in the discharge of his official duty, except with the previous sanction of the central government. So again, for armed forces, we require sanctions from the central government. Now, the primary test should be that we need to consider whether really the act purport to be discharge of the official duties or not. So if the act is purport to be discharge of the official duty, then sanction is required. So this section is a very significant sections in respect of these sanction provisions. Now, just think about a situations, say, for example, an army officer or BSF personnel allegedly, after their duty, when they were going back on the way somewhere in the villages, the border area, they allegedly committed sexual offences. Does not require sanction. Something which is not the part of official work, that does not require sanction, but other cases sanction is required. In clause 3, no court shall take cognizance of the offence alleged to have been committed by any member of armed forces charged with maintenance of public order when 356 article was used. So when a state was dissolved or some armed forces are there in the state, now they require sanction for those officers, etc. And rightly this provision was there. Clause 5 says the central government or the state government may determine the persons by whom the manner in which the offence or offences for which the proceedings of such judge, magistrate or public servant conducted may specify court before which the trial can be conducted. So that basically procedural element, but the requirement of sanctions. So one new good thing what we added in the new law provision is deemed sanction. So if within 120 days, if the government did not refuse that will be considered as deemed sanction under the law. Same way, we find the sanction requirement are also there in some special laws. For example, under Arms Act 1959, there is a requirement of sanction. Custom Act 1962, there is a requirement of sanction. So no court shall take cognizance of any offence under 132, 133, 134, 135, 135A, etc. So how we determine the test for sanction? Whether in those circumstances really sanction is required or not. In state of Odisha versus Chandraju, court says so real idea was that whether the act which the persons purport to be in the discharge of official duty will fall within that category or not, how you decide. So it says that one of the tests will be, suppose if those kinds of a work that public servant will not do, will that amounted to negligence or dereliction of duty? If the answer is yes, then sanction is required. So any work which police doing or other person doing against whom the case is supposed to be filed, if those works they will not do, will that amount to dereliction of duty, then sanction is required. That's the principle in this case has talked about. Lal Singh University of Gujarat, even if the cognizance is defective, it can cure later on. The state of Himachal Pradesh was the MP Gupta, sanctions requirement of 197 when. Now this protection has in certain limits and is available only when alleged act done by the public servant is reasonably connected with discharge of his official duty. So remember, if it is in the discharge of the official duty, then we require sanction is the necessary sanction requirements are there. But when it is not in discharge of the official duty, then there is no requirement of the sanction. MP Gupta, obtaining sanction of prosecution of a retired public servant. Now, in this earlier provision 197, there was a subsequently they amended whether a public servant is in service or was in service. That means the alleged act was done when he was service, we require sanction. So 197 provides that when any person who is or was a public servant not removable from his office, save by or with the sanction of the government, is accused of an offence alleged to have been committed while acting or purporting to act in discharge of official duty, no court shall take cognizance. So there's a requirement of sanction in those circumstances. So Law Commission, there's a discussions in 41st Law Commission's report, and where Law Commission says if we don't use the word was in service, then the people will wait for retirement. After retirement, they will file the case. Question is the time when the alleged thing was done. If it is was in service, they need to protect it, and accordingly, after expression is was also was used in these sections. When sanction is not necessary, basic principle same. When the concerned act, etc., is not the part of official work. So say, use of filthy abuses and assault by the inspector of police. No, that is not their duty. Police arrested someone beaten to death outside the police station. They have interrogate, but they cannot have power to kill someone. or cases like Mathura rape case. Now we have explicit provisions under the law. So if the act is not purport to discharge in the official duty, then sanction does not require. Balkis Singh Brar, competent police officer, sanction after taking evidence. R.S. Mathur, police cannot be directed to obtain sanctions for prosecution against public servant. What police will do is prerogative. We discussed in the last class that investigation is completely prerogative of the police department. So how they will act, what they will do, it is their prerogative. Manoranjan Prasad Chaudhary, prosecution vitiated without sanctions. There are many cases when the sanction is not obtained. So it can be vitiated. So petitioner pleaded for discharge on the ground that appropriate authority had not accorded sanction under 19 of the PC Act. The authority competent to remove the petitioner from the office is the authority to accord sanctions, and the said authority is the managing director of the company. Since there is no sanctions of the competent authority, the proceeding is vitiated. So that also possible many cases. Now, this is a very interesting case, MP Special Police Establishment versus State of MP. So many officers were involved. Lokayukta cases has been started. Now remember, now the Lokayukta exception has been given in the law that when case is started by Lokayukta, sanction does not require, otherwise sanctions require. So Council of Ministers refused sanctions. Now a Council of Ministers refuse sanctions, then both the ministers successfully challenged the order. So High Court says that, okay, Council of Ministers has not given sanctions. Accordingly, matter cannot proceed further. Supreme Court says that no. So Council of Ministers refuse, but governor given sanction. So under the Constitution, remember, the governor has to act in aid and advice of the Council of Ministers. So the challenge was in the High Court that the governor has given sanction without aid and advice of the minister, because minister has refused to give permission for sanction to the governor. But governor himself has given sanctions. Supreme Court says that if you allow dismissal of these kinds of cases, or then every ministers will do after corrupt practices, they will not give sanctions, they will not allow the governor to give sanctions, and there will be impunity. So it will, they use the word, if we don't allow, the governor cannot act in his own discretion, there would be a complete breakdown of rule of law, in as much as it would be open for the government to refuse sanction in spite of overwhelming material, showing that a prima facie case is made out. If in cases where prima facie case is clearly made out, sanction or prosecution of high functionaries is refused or withheld, democracy itself will be at stake. So such a broad wording with the Supreme Court says. So Supreme Court approved the sanction which was accorded by the governor. Sanction stage, which stage? It can be at any stage, even many times at the stage of trial also can be taken. Officer of the state government working in cooperative society on deputation, whether sanction of the prosecution is necessary. Now, it depends on the rules. So here, he at the relevant time was not in the service of the state, and under the concerned cooperative laws, he was not a public servant. Accordingly, prosecution against an officer of the government company or a public undertaking would not require sanction under 193. That's the view court has taken. Sanction obtained against a person, whether court in exercise of his power under 319 CRPC can summon another person when there is no sanction against them. Law permit, normally we allow the persons so to add. Sanction must precede application of mind. No, that's the general principle that any authority who gives sanction must apply their mind. That's a basic principle. Specification of each of the offense in the sanctions not necessary. Some minor omission will work. So Prakash Singh case, Prosecution hit by provision under 197(1) sanctions if condition precedents. So yes, sanction is required, but prosecution hit by provision under 197(1) cannot be launched without the sanctions contemplated. It is condition precedent, though the question may arise necessarily not at the inception, but even at the subsequent stage. It may also arise in some cases where after some evidences when the court will take, then court will satisfy this is a fit case where we can get sanctions or not. Obtaining sanctions of a prosecution of a retired public servant necessary. Answer is yes, if the act in discharge of the duty, then the sanctions are required. Prosecution vitiated without sanction, Prevention of Corruption Act, there are possible. We discuss some other cases also. Complaint against police officer, sanctions after taking evidence, that possible. So complaint against police officer for causing death of a victim. Cognizance taken for offence under 302, 323, 149. Well, IPC. Trial court knowing that it could decide necessity of sanction after gathering detail and evidence. Order is legal because the trial court also has to satisfy whether the act which done by those public servant was in purporting to be discharge of the official duty or not. If it is purporting to be discharge of the official duty, then sanction is required. But if it is not purporting to discharge of official duty, sanction does not require. 482 is the High Court inherent power. We are not concerned here. Now, these are another provisions of prosecution for offences against marriage. Here also, what I was saying, that those offences under IPC, the complaint can only be filed by the aggrieved party. So many times, despite the fact that you have instances of bigamy, we have instances of adultery, but in reality, we don't find cases of adultery that much, bigamy, because of this section. It put restrictions that only this class of peoples can file cases and no other. Prosecution offense under 85 of the Bhartiya Nagarik Sanhita is basically replica of 498A cases. So there also only either the aggrieved persons or her father, mother, brother, sister, or by her father's or mother's brother or sister. So only specific cases or leave of the court by other persons. So there is a limitation which is there under the law. 221 talk about the cognizance of the offence under section 67 of Bhartiya Nagarik Sanhita, where the persons are prima facie marital relationship, then complaint can be filed by the wife against the husband aggrieved party. Prosecution for defamation. Now, this is the last section of this chapter on here. This is the only circumstances in the BNSS. It was only circumstance in CRPC also, where the prosecution for defamations against the president, prime minister, governor, administrator of union territory, minister of a union or state of a union territory, or any public servant employed in connection with work of the union, etc. Now, only in these cases, defamation is the only circumstances where law says the public prosecutor will file a case directly in court of session. In all the circumstances, the session court is not originating court. The cases transfer from magistrate court to court of session. 222 in the new act is the only exception circumstances where the session court take cognizance directly when there is a defamations, etc. against these high profile people. And then the procedures are there. Earlier it was section 199 CRPC, that's become this section. Okay. So that's basically the provisions what we look at on the cognizance and sanctions provisions. Now we'll come to our third part. Last component, which is about the complaint to magistrate and commencement of proceedings. Now, there's a very significant changes has been brought in the new law, which was not there earlier. So, on the CRPC from 200 to 203, and then BNSS 223, 226, then 204, 210, 227 to 33. Basically, 223 to 233, that sections are there, which deal with the entire process of how the complaint case are being filed. and their processes. And there are some changes which have been brought in the new law, which was not there earlier in CRPC. So first is 223, examination of complaint. Now, when people file a complaint in the, we call it complaint cases. So earlier they used to file under section 200 CRPC. Now it is 223 CRPC. By and large, you find the same wordings are there. The proviso has been added there, and there's a very significant additions. So 223 says a magistrate having jurisdictions while taking cognizance of an offence on a complaint shall examine upon oath the complainant and the witnesses present, if any, and the substance of such examination shall be reduced to writing and shall be signed by the complainant and the witnesses and also by the magistrate. So that's the first process of witness will say a sub statement, then my court will also sign. Now this is the normally we say essay process. So it is only for the court for satisfaction. Before taking cognizance, court is satisfying that whether this is a fit case to take actions or not. Now they have added a new proviso, and the proviso says, provided that no cognizance on offense of an offense shall be taken by the magistrate without giving the accused an opportunity of being heard. Now remember, when court take cognizance, that's the first step a criminal case start. Under the new law, even before the real criminal case start, law expect that the court should send notice to the accused persons, give him opportunity of being heard. Now this is the new thing which was there in the law. Earlier it was not there. Provided further that when the complaint is made in writing, the magistrate did not examine. In these circumstances, when a public servant acting or purporting to act discharge of official duty, or a court has made a complaint, then you don't follow this process of examinations. B, if a magistrate make over a case for inquiry to other magistrate, you don't require this. But also that if the magistrate make over the case to other magistrate, then examination of common witnesses may later magistrate, that also possible. So, but the new thing which they have added is that before even taking cognizance, the accused need to be given an opportunity being heard. So case has not started, but before that we are giving opportunity. 2 says a magistrate shall not take cognizance on a complaint against a public servant. Now again we have seen this similar thing when we look at 175 clause 4. If you remember, the same thing had it here in complaint also. If someone's want to file a case against a public servant, then here the before taking cognizance, magistrate will first ask that public servant the circumstances in which this entire thing was happened. Magistrate will call for report from the superior officer of those public servant about the circumstances of the incident. So that means that when you want to file a case against a public servant, in those circumstances, there is another obstructions or some requirements of the law is there to satisfy to the magistrate, and magistrate will ask from those public servants about why this happened, how this happened, and from their senior also they will give address the magistrate the circumstances. Now 224 says procedure by magistrate not competent to take cognizance of the case, then normal procedure can be transferred to other magistrate or ask the complainant to withdraw. 225 postponement of issue of the processes. So in some cases, magistrate will not proceed, and so any magistrate on receipt of complaint of an offence which he authorized to take cognizance or which has been made over to him under 212 may, if he think fit, and shall, in cases where the accused is residing at a place beyond the area in which exercises his jurisdiction, postpone the issue of process against the accused and either inquire into the case himself or direct an investigation to be made by the police officer or by such person as he think fit for the purpose of deciding whether or not there is a sufficient ground for proceeding. Now, very important section. So under earlier it was 202, now it become 225. So someone has filed a case to the magistrate. Uh, from the magistrate, from the essay, the magistrate is not sure from his statement. So what the magistrate can do? Magistrate can send under 225 for police to investigate and submit report. Now, this is not the same investigation under after FIR. Now, because this investigation can be done by other person also. So either to police or by such other person as you think fit. So say some of you are residing in a residential campus of a university, and your hostel, some fight happened between the two students. One student appeared to the magistrate for filing this complaint case. Now, one way magistrate can ask the police to investigate and submit the report, but then bringing police to the hostel again does not look good. Can magistrate direct the registrar or chief warden to investigate and submit report? Answer is just possible. So this permit either police officer or by such other person. So law are very flexible in some cases where the investigation can also be done by the other persons. And then the remaining processes are there which you can read yourself. So in Ramdev Food Product Public Limited versus State of Gujarat, court says scope of power of police under 202. Uh, they have explained because this investigation is not same as investigation done after registering FIR. So powers are limited. They don't have power of the accused. Those are not available in these cases. So 41 is not available. If they want, they can ask for warrant from the court and not otherwise. The police officer does not have any power to arrest without warrant because it is under 202. It is investigation is for a specific purpose. He will investigate and submit report to the court. That's the only thing they have to do. 226 says this report came, magistrate satisfied there is no material, magistrate can dismiss. But if they don't dismiss, that means there is a material, then under 227 magistrate can issue notice. Earlier it was 204. So that's the process by which criminal trial, the process is start, where under 204 earlier, now under 227, the magistrate will issue notice. So it says, if in the opinion of the magistrate, taking cognizance of an offense, there is a sufficient ground for proceeding, and the case appeared to be a summon case, he shall issue summon to the accused. Warrant case, he may issue warrant case. Now, he may issue summon also, if he think fit, or a summon for causing the accused to be brought, provided that the summon or warrant may be issued through electronic means. That's the new additions. So now the summon or warrant can also be issued by electronic means. No summon or warrant shall be issued against the accused until they have put under subsection 1 until a list of the prosecution witness has been filed. In proceeding instituted upon complaint made in writing, every summon or warrant issued under subsection 1 shall be accompanied by a copy of such complaint. So when court issues summon, the complaint copy will go along with that summon. When by any law for the time being in force, any process fee or other fees applicable that they have to need to pay. So that basically procedure in which summon is being said. So whole idea is when the case is not being dismissed, that the next step is sending the summon to the accused along with the complaint cases so that they can appear and the case trial can start, process can start. So Lina Vivek Masal, it was the state of Maharashtra. Court says about the issue of process summon. So order issuing process summon against the appellant accused cannot be interfered by the Supreme Court in the appellate jurisdiction under Article 136. Recall of the order refusing to issue process. Recall of the order refusing to issue process by subsequent order impermissible. That's what the court has says. Issuing process against the director. When a company is accused, the director can be roped in only if A, there is a sufficient incriminating evidence against them coupled with criminal intent, or B, the statutory regime attract doing so a vicarious liability. There are many things under the Companies Act. The company can also be accused, director can also be accused. So there are many times the liability comes of the director also. 228 says magistrate may dispense with the personal attendance of the accused. So in some cases, magistrate may allow that the accused does not need to do some personal attendance. Special summon in cases of petty offences. They laid down the process for the special summon because the petty offences can be disposed of separately. Sometimes it's only fine. 230 supply of the accused of a copy of police report and other document. It was earlier under section 207 CRPC. Now it become 230. It's a mandatory process. Any cases to proceed further, accused has a right to get the copy of the entire report, police report, and the other document free of cost. This is the rights of the accused and even the committing court. So suppose a charge sheet submitted in CGM code or ACGM code, that code will ensure that the copy is served under 230 and thereafter case can be sent for commitment. So any commitment or transfer of case to court of session, this is a prerequisite process under 213 where copy of the entire charge sheet and other documents are given. So what are those things? The police report, first information report, statement recorded under a 180 or 193, etc. Confessions statement under 183, etc. Other document under 193. So all these things need to be given to the persons. So in P. Gopal Krishnan versus State of Kerala, the Supreme Court says that principles clarified relating to scope and obligation at 207, that what section now become, that the accused has a right to get the copy from the court. So this is one of the rights and contents of the memory card, pen drive, video footage, appended to police report can be treated as a document and consequently a clone copy thereof must be supplied to the accused. They should get copy of it. 231 supply of the copies of statement and document to accused in other cases tribal by court of session. So the in cases instituted otherwise than a police report, it appeared to the magistrate issuing Precedent 227 that the offence is triable exclusively by court of session. The magistrate shall forthwith furnish the accused free of cost a copy of each of the following statement, etc., other statement, and then the commitment proceedings will happen. Commitment of the case to court of session when offence is triable exclusively by it. So when the cases are triable by court of session, these the sections from where the case will be transferred to court of session. So 232 says when in a case instituted on a police report or otherwise the accused appears or is brought before the magistrate and it appears to the magistrate that the offence is triable exclusively by court of session, he shall what he will do? Commit after complying with 230 or 231 supply of copy. Then it will commit. Subject to provision of the Sanhita relating to bail, remand the accused to custody. Either they can give bail or they can remand the custody there. Send to the court the record of the case and the document, etc. Notify the public prosecutor about the commitment of the case so that they can follow the case in the court. Provided that the proceeding under this section shall be completed within a period of 90 days from the date of taking cognizance. Now, earlier timeline was not there. Now, the timeline has been mentioned. So, this process, etc., has to be done within 90 days. Provide further that any application filed before the magistrate by the accused or the victim or any person authorized by such person in a case triable by court of session shall be forwarded to court of sessions with the committal of the case. Sanjay Gandhi versus Union of India, the committing magistrate has no power to discharge the accused if the offence is triable exclusively by court of session because they will do. The court which can frame the charge, they can discharge, not the magistrate. Hardeep Singh versus State of Punjab, stages of committal of the case to the court of session is neither stage of inquiry nor the trial. So, 233, the last sections of this part, procedure to be followed when there is a complaint case and a police investigation in respect of the same offense. Now, what to do in those cases? So, it's a peculiar circumstances. You have one case where someone went to the court and someone went to the police, registered an FIR, and later on he filed a complaint case. This section permit that both the sections can be clubbed together. Court will call for that police report, etc., and then both will club together, and then the matter can proceed. So, under these sections, the two kinds of cases which are there, they can club together. So, 233 clause 1 says, when a case is instituted otherwise than on a police report, that means complaint. It is made appear to magistrate during the course of the inquiry or trial held by him that an investigation by the police is in progress. So on the same issue, the separate investigation is going on. Then what to do? The magistrate shall stay the proceeding of such inquiry or trial and call for report on the matter from the police officer conducting investigation. So magistrate will stop this complaint case, ask for report from the police. If a report is made by the investigating officer under 193, that means police report they submitted. And on such report, cognizance of the offence is taken by the magistrate against any persons who is accused in the complaint case. The magistrate shall inquire into or try together the complaint case and the case arising of the police report as if both the cases were instituted on police report. So the process will be of the police report as if both the cases were instituted on police report. If the police officer does not relate to any accused in complaint case, or if the magistrate does not take cognizance of any offence on the police report, etc., with such inquiry or trial, which was stated by him in accordance with, so then can proceed that inquiry, etc. So this is the process when there are two cases started from there. Now, in many time in the judicial service examination, these questions from these sections appear earlier. For 210 CRPC, it was now become 233. Okay. That basically the thing what we have discussed today.